Mr. Nominee, that it is spurious and disingenuous for you to suggest that the minister can, on this basis, refuse to grant the license renewal. But even if we were so, damages will still flow and the government of Ghana will remain liable. Mr. Nominee, it will interest you to know that about 2 weeks ago, this company, Cassius Mining, for which you were once their legal counsel, has filed an arbitration against the government of Ghana, claiming in excess of 440 million United States dollars at the London Center of International Arbitration. The Attorney General of the Republic of Ghana is supposed to defend the Republic against all claims, including one such as this. Now, you were once the lawyer of this company. You believed in their claim against the government of Ghana. Mr. Nominee, are you going to ensure that when the Republic goes to defend this claim, the Republic of Ghana will not be burdened with this $441 million? And I'm saying this because of the appearance of conflict of interest.
I recognize Honorable Kwame Agboja.
Leader, the procedures here will all encourage our first-timers to participate fully in this. Indeed, that is why our side and the side of the minority brought in first-time MPs. But in this committee, you can lay preamble to ask your question, but not to make, endless statements. And I sit here and I ask myself, when is the question going to come? So, Chairman, can you direct that it is not against the procedures here to lay a preamble, but that must be brief, then you go to your question. Because I get lost as to whether somebody is making a statement or asking a question.
You see, Chairman, people, Honorable Whip, people sit outside and sometimes they bash the members of the committee. Being outside and having the opportunity to ask the question are two different things. You now have the opportunity, pose the question, but I will allow the nominee to provide an answer.
Thank you, Mr. Chairman. Mr. Chairman, the honorable member is right. I have been instructed previously by Cassius Mining. I filed pleadings in the High Court in Bolgatanga together with my junior partner, Mr. Gorin Tamaklo. We litigated, various applications before the courts. I want to put it on record that I'm no longer Cassius Mining's lawyer. However, I'm keenly aware of the fact that the Constitution prohibits a situation where a public officer puts himself in a position where his private interest conflicts with the performance of his public duties. As Attorney General of the Republic, I will be the Republic's lawyer. As the Republic's lawyer, I am supposed to act in the best interest of the Republic, in accordance with the best traditions and ethics of the legal profession. I will not, in any manner whatsoever, compromise the interests of the Republic of Ghana. Honorable Member, if you care to know, and I'm sure you are very well aware, that I was Deputy Attorney General under the former Attorney General, Honorable Marietta Brew. And for 4 years, we handled that ministry in such a way that the US government described the Attorney General's office as a corruption-free zone. We handled the ministry in such a way.
You are not supposed to take part in the proceedings. So remain silent and observe the proceedings. You are only here to observe.
So, Mr. Chairman, when we were in office, you can go back and check the records. There was no single incident, except the Wyoming matter that came before we assumed office. There was no single incident of questionable judgment that's arising out of or in connection with the performance of the obligations of the Republic in any contract or legal transaction. So I can assure the House that I will take measures if they are before the London Court of International Arbitration. I'm quite familiar with that tribunal. I've appeared before that tribunal several times, and I can assure you that I will put in the measures that will ensure that the interest of the Republic is not compromised.
Mr. Nomini, your firm is on record as having acted for a number of companies which have gone on to make huge claims against the government. In some of these cases, the companies were formed between the year 2013 to 2017. Your firm was the law firm which acted as lawyers for the firm. For the firm, at the same time, you were the Deputy Attorney General. After you left office, the companies proceeded to go on international arbitration against the Republic, claiming millions of dollars. We have an example in GPGC, which was the claimant in the Trafigura arbitration case. Mr. Nomini, your law firm's address, Ayine, Feli & Co., is
Honorable John Dako. The nominee told the whole world that he is mindful of the conflict of interest situation. When he was a Deputy Attorney General, nothing of that nature happened. He is now before us to be vetted for the position of the substantive Attorney General. Why do you keep on asking questions relating to his law firm?
Mr. Chairman, I think it's very important. The honorable nominee, which I know very well, is going to be the chief enforcer of our laws. And so, Mr. Chairman, and he's capable, I know him very capable of answering any question posed to him.
It is so not the capability,
Mr. Chairman.
It's not the capability of answering the question, but we need to be guided by the rules. You know, the law firm Ayine and Associates is different from Honorable Dr. Akuritinga Ayine.
Yes. Yes. So it doesn't mean that he cannot answer. When there is a semblance of conflict of interest, I think that it will be in his own interest to answer that question, to clear the minds of all of us.
Honorable members, do you have any further question?
Mr. Chairman,
I ask the nominee not to answer such a question. I will now give the floor.
Mr. Chairman, I think you are being unfair to me. Yes, Mr. Chairman, if you believe that, for instance, this question...
Did you say I'm being unfair to you?
Yes, Mr. Chairman, with respect.
Why do you say so?
Because, Mr. Chairman, you are not allowing me to ask the questions I'm supposed to ask.
But I have the right to overrule you.
We represent...
We are guided by rules.
And the people need
But we are guided by rules.
The people must hear...
Are you aware we are guided by rules?
Yes, Mr. Chairman, but I don't
You cannot even ask incriminating questions.
I don't think at this point I have violated any rules of this House. Mr. Chairman, I haven't...
Where lies the question of conflict of interest? When the nominee has already provided the answer.
Mr. Chairman.
Honorable John Dako, you are out of order. I give the floor to Ahmed Shaibu.
Order, Chairman.
I give the floor to Honorable Ahmed Shaibu.
Chairman, order. Chairman, I want to intervene.
We have Ahmed Shaibu and Muhammad Shaibu.
Chairman. Colleagues.
Honorable Minority Leader, you have the floor.
Chairman, before before I go into colleagues, please, let's resolve matter. Chairman, I am making this point. If you check our rules book, you have the chairman of the committee and you have the vice chair, and you have the ranking and you have deputy ranking. In principle, what our standing orders is trying to say is that there is a presumption of a co-chairing of this exercise. To allow, otherwise, if you will never, you would always want to have your say, but you don't want others to speak. That is your problem, NDC. That is your problem. Yes, we don't judge. Okay, if that is what you want to do, so you're right, no problem. You will listen to me. Chairman, you can't say out of, you can say, you've said that to my members. If you now want to extend it to mean that I'm out of order and all that, let's have it.
If the standing orders,
can the vice chair leave?
if the standing orders has any,
Can I finish? Can I finish? Can I finish, my respected vice chair? Can I finish? Chairman, we are here. We are here to work as a team. The rule talks about the chair and vice chair. If this committee is to deal with a sole chair without anybody to work to express a view, it would have limited it to chairman and vice chair and nothing else. In Parliament, whenever there is a chair, there is a ranking. It is not to checkmate, but to work together and to express views of the House. When we try to put issues across, we have some of your senior colleagues who reach out quietly to say, oh, please, you are going too much. We listen to them. We want to work together. But Chairman, with the greatest respect, I have observed consistently the way you go at my members, especially the young ones, the new ones. It's not the right way. I've been quiet watching, and I'll just be pinching you, the chairman. Please, you take it easy. Take it easy. But the way it is going, I think it is not too right. To the extent that, as your co-chair, and I want to state this on record, well, the standing, don't worry. If you give it a purposive interpretation, it will lead you to that conclusion. Please, let's understand each other. This vetting should have taken place tomorrow, all three of them. We mean well, and I want to state that on record. We mean well as a minority. We cooperated to have this 21 days or 15 days notice to be waived so that you can form your government as quickly as possible. I am pleading with you, Chairman. Chairman, I am pleading with you. I do not. Can I finish? No, I'm not done. I want to be honorable Mahama Yerga. I need to be done. I would have to be done. I do not like this situation whereby your side is still behaving as though you are in the minority. You are not in the minority. You are now in government. Please, we mean well. It is the reason why we are here. Stop the approach you are adopting. I am pleading with you. I am humbly pleading with you, Chairman. have made your point.
Are
We
you done?
plead with you. The approach will not help all of us. The approach will not help all of us.
You see, honorable members, I will give the floor to...
Chairman, he did not finish. Please. No. Chairman. The gentleman, no, Chairman. No, he didn't finish. No. He had called somebody. Chairman, all my plea is... Chairman, I beg you, allow him. Chairman, please. Chairman, please.
You see, honorable members, we don't sit here to gag any member, but we rather give you directions. The fact that we are guiding and giving you directions as an honorable member of parliament, you should take a cue and proceed. If I want to apply the rules strictly, as the former First Deputy Speaker have been doing, what happened today, we may not be experiencing some of those things. According to him, you are asked to ask a question, you ask the question, but we have allowed you to run commentaries, sometimes to read write-ups before asking the question. So I would urge all of you, particularly the new members, to take guidance from the chair. We are here to guide you.
Then you guys should do your thing since you are in your majority. If that's what you do, we'll leave.
We are to guide you. So if you still have one more question, you may proceed to ask the question. I beg you. I'll give you the floor after that.
We have waited the whole day. If you are working out now, then you are. You leave. But you look at what is done to me. No, you have spent the whole day.
Hold on with your question. Let me give the floor to Honorable Kwame Agoja.
Chairman, you see, nothing happening today.
Please, let's have order. Order.
Chairman, what the minority leader said about NDC being intolerant or they have been more cooperative is totally untrue. Mr. Speaker, Mr. Chairman, we've had situation when the president nominated people on Friday and we came here on Saturday to fetch the people. No advertisement or anything. So what is the minority leader talking about? That they have been more cooperative than us? That is not true. What we are saying is that, yes, indeed, we've had first-timers in the house, indeed, in the chamber. We've seen first-timers from both sides walking across the maze because they were not yet gone through orientation. So when, unfortunately, they haven't gone through full orientation, they come to committee, and instead of asking questions, coming to read statement, it is appropriate we put them right. That should not be a situation anybody could interpret to mean that somebody is being gagged. And let it be known, as a matter of fact, at the appointment committee, we never allow friends or non-members to ask questions. It's because we wanted to carry everybody along that we give them the opportunity. So, Chairman, I would encourage you once again, stick to the rules. When you give an opportunity to somebody to ask questions, let that person ask the question and let's move on. This endless rhetoric of trying to quote things and never relate it will not help anybody. Mr. Speaker, Mr. Chairman, let's make progress, but let everybody who gets opportunity ask the question and let answer the question. Chairman, I also noticed, anyway, you go.
Thank you very much, Honorable Nkommo Wo.
Thank you, Mr. Speaker, Mr. Chairman, for indulging me. I am very much concerned about what is happening here. And in as much as we don't want it to look like newcomers are being gagged, I think that parliamentary practice and procedures transcends the presence of this parliament. If we want to do it, we have to do it right, because you'll be going out there meeting other parliaments. So in the name of supporting first-timers or newcomers, all of us are still learning. But if we refuse to learn the right way, we will go out there and embarrass not just ourselves, but the Parliament of Ghana. So I'll plead with us, in as much as we want everybody to have the freedom to express himself or herself, let us do it within the laws. So that when we go out there, we'll have the confidence to operate. Leadership will not be there all the time to protect us. Even leader might not be on the floor of Parliament every time we have to rise and talk. So if we don't learn it the right way, we are the ones who are going to suffer. So I'll plead with you, let's do it the right way. Thank you.
And put on the microphone without being given the floor. We've been tolerant. It doesn't happen anywhere that you get up and then you put on the microphone. Somebody is asking a question. Then you said you are on a point of order. How do you take point of order on a question being asked? Well, you said you have one question more. May you proceed to ask the question.
Mr. Chairman, thank you very much. I want to believe that everything is being done from a good
John,
place.
can you proceed with your question? Can you proceed with your question?
Yes, leader, thank you. So, Honorable Nominee, my question is, have you filed your asset declaration?
He's asking whether you have filed for asset declaration.
Yes, I have. I'm always compliant with asset declaration. I mean, the filing of asset declarations. I've done that. Not for 2025, but for the last Parliament, I filed my asset declaration.
Which is 2020, ending 2024?
Yes.
Okay. But I don't think the committee has a copy or evidence of filing. When I'm looking at the Constitution, if you look at the Constitution, Article 286, yes.
If you have a follow-up, please go ahead with your question. The follow-up.
Yes.
Before you come in to ask the question,
Yes.
I want us to be guided by the constitutional imperative in Article 78, which states that for you to qualify as a minister, you must qualify to be a member of Parliament. The nominee before us has just gone through election and was elected the 4th time as a member of Parliament and sworn in as a member of Parliament. So let us be guided by the constitutional imperative in Article 78 and 94.
All right, thank you, Mr. Chairman. So, Mr. Nominee, your law firm, that is Ayine, Feli & Co., is on record to have been used as a registered address for a company called GPGC. Now, my question is, did you advise on the agreement between GPGC and the government of Ghana, of which you were the Deputy Attorney General then, and which led to a judgment debt of $134 million against the state?
Okay. So, Mr. Chairman, it is important to set the record straight because this is a House of Record. This is a Committee of Record. I became Deputy Attorney General, I think, in April 2018. When I was nominated, because I did not have the right to practice, my firm, or the firm of lawyers to which I belonged, was being run by Dr. Abdul Basit Bamba. And when GPGC came into Ghana, he was a lawyer who was approached to help them navigate the process of company registration. And he was the one who registered the company for them. And he had the right to do so to earn a living. He wasn't banned from practicing because I was Deputy Attorney General. Subsequently, Dr. Abdul Basit Bamba left Ayine and Fele, now Ayine and Partners. And when he was leaving, because GPGC was his client, he took them along. Okay? At the time of their PPA, he was no longer a member of my law firm. And I had no dealings whatsoever with GPGC in my private capacity prior to being nominated and appointed Deputy Attorney General of the Republic. And my former boss, the Honorable Marietta Brew, was very gracious to me because I came from academia. And one of the things that the subjects that I taught, and I'm sure you took my natural resources law course, I was the head of the natural resources law department that included, petroleum. So she, subject to reporting to her, I was in charge of the petroleum and energy aspects, of any transaction that came to the department. Yes, so I issued a legal opinion on GPGC, all right, which was, because the PPAs are standard, the provisions are standard. You can take any normal PPA, the variations are not many. So I issued a legal opinion for them. I mean, I signed it for and on behalf of the Attorney General. So technically speaking, it was Honorable Marietta Brew's opinion, not mine. But whatever the case, when the dispute started because of the actions and omissions of your government, I was no longer in office, and I never acted as a private legal practitioner in any of the disputes. Mr. Chairman, that's all I can say for now.
I believe you have exhausted your questions. It is now the turn of
Thank you.
Jerry Ahmed Shaibu.
Dr. Ayine, congratulations.
Thank you.
Look, in 2021, during the hearing of the election petition, you were cited by the Supreme Court of Ghana for scandalizing the court. The matter was referred to the General Legal Counsel. The matter is still pending. My view and my question is that, are you, with all due deference, not in the position to have the matter resolved before you take up this high office of Attorney General and Minister of Justice? Thank you.
Yeah, thank you, Mr. Chairman. Thank you, Mr. Chairman.
Honourable member, before you come in, the matter is pending quasi-judicial decision. I believe we have a lot of members of parliament who have been sworn in with the matter pending judicial decision. To what extent does a member's involvement in a pending lawsuit disqualify him from being a member of parliament, let alone a disciplinary proceedings against a member? So, with all due respect, we need to be fair to all manner of people, and we ask very fair questions to the nominees. So, ask another question with all due respect.
Mr. Chair, thank you very much. I'm not too sure if I can respond to your question before going to the other question.
See, that is why I've indicated that the practice in the House is that you are guided by the chair. You are guided by the speaker. So you take the guidance and proceed accordingly to ask another question.
Very well, Mr. Chair. I take a cue. Dr. Ayine, during the Mills Mahama government, in which you served as the Deputy Attorney General, the state lost a number of international arbitration cases and local ones as well. And to a larger extent, some amounts of monies involved were quite humongous. My question is that how do we prevent the recurrence of such situations? And the case that comes to mind is the Balkan case. Thank you.
Thank you very much for your question. Dominic, your answer, please.
Yeah, Mr. Chairman, there is never a perfect government, and so sometimes public officers act in a manner that incurs liability for the Republic. But as I said, when we were in office, we did very well in trying to prevent such situations. The Balkan situation arose before I took office as Deputy Attorney General. And in fact, by the time I was Deputy Attorney General, the arbitration was at an advanced stage. In fact, I think they were awaiting the award. And the award came down in favor of Balkan. I think it was about $12.5 million or something to that effect. $13 million in favor of Balkan. For us to be able to prevent such situations, state actors, I mean the ministries, departments, and agencies, and the public officers must make sure that they do the right thing. So, for instance, one of the things that I want to emphasize, which we started briefly before we left office, was for us to conduct legal due diligence, of all companies that are seeking to do business with the government, especially where the stakes financially are very high. And so we will attach the legal due diligence report, even if we ourselves cannot do it. We'll get private law firms to conduct the legal due diligence so that we do the right thing by the law. Mr. Chairman, I think we're all in this country when a certain huge transaction came before Parliament, and then when the company was being traced to London, we realized it was a hairdressing salon, CNTC, and it was not President Mills who was in power. It was not His Excellency John Dramani Mahama who was in power. It was His Excellency John Kufuor, a man that I respect very much, whose government was in power. It was a hairdressing salon, Mr. Chairman.
Thank you very much. Any follow-up question?
Last one. Thank you, Mr. Chair. Dr. Ayine, so my last question is, what are the kinds of agreements that ought to receive parliamentary approval under Article 1815 of the 1992 Constitution?
I'm surprised my former student is asking me this fundamental question. Where there are loans, loans and, international economic or business transactions in which the government of Ghana is party, or to which the government of Ghana is party. Thank you, Mr. Chairman.
Thank you very much. We now take a question.
Congratulations, nominee. Doc, I want to refer you to an interesting case. A case of a company called Eland International. And I want to believe that you are familiar with the company Eland International. And in laying the foundation, just for a minute before my question, Eland International, sometime in our history, had a case and made a claim subsequently to the international arbitration, where, as we speak, since 2005, they only waited to file these arbitration claims of $320 million against the government and the state of Ghana. I'm also reliably informed, and I stand to be corrected, that sometime 2014, 2015, when you happen to be the Deputy Attorney General, you tried to settle this matter somewhere in India and Dubai. said I stand to be corrected on that. But there was somewhere in 2014, 2015, in your capacity as a Deputy Attorney General. Now that they have filed these claims of $320 million, and being a company that you are familiar with in terms of the history of this case, what assurances can you give the people of Ghana, and for me, my constituents in Akuapem North, that our incoming principal legal advisor to government will be fair in handling this matter so we do not lose revenue? And I'm asking this because respectfully, if you will just observe, many of the questions hovers around judgment debt. And I'm not taking a partisan position on this matter. And it's because the state, over several decades, we have lost significant revenue through some of these claims, whether under government A or government B. So it's become an industry for some people, an element that some operate across these political parties. And also lastly, for the record, it's not just Woyome case that preceded you, but also under the same Mills Mahama government, you had Isofoton and the rest as well, just as a matter of record. Thank you.
Thank you, Mr. Chairman. I want to put it on record that I have never served as counsel for Elan.
No, I never said you did.
Yes, I was involved in two aspects. One was the case, the famous promissory note case that was brought by Standard Bank Offshore Trust against NIB. And then I served as the lawyer for NIB. As the first defendant, Elan was the second defendant, but had a completely separate legal representation. So I've never served as their lawyer, so I'm not conflicted in any way. I also want to put it on record that I am not aware of this arbitration that you have referred to. And Mr. Chairman, I believe we are a committee of Parliament, but there are certain rules and practices and conventions of the legal profession that we need to abide by very, very carefully. When a matter is pending before arbitration, you are not even supposed to discuss it. That's what is the position. Even when an award has been granted, especially when it is before bodies like the London Court of International Arbitration, the International, the Permanent Court of Arbitration, etc., you are not supposed, to discuss them. But as Attorney General, I will take all the steps that are necessary, as I said, to protect the interests of the Republic. Because once I'm sworn in, the Republic is my is the only client that I have. And I must act in the best interest of the client in accordance with the ethics of the profession. So I'll do everything in my power to ensure that we defend vigorously the interests of the Republic in this arbitration that you are referring to.
Thank you very much for your answer. I will allow you one follow-up question, if any.
Thank you very much, Mr. Chair, and thank you for your generosity this evening. Mr. Chairman, I think it will also be hugely unfair for the Parliament of Ghana to be precluded from discussing a matter because it's also pending before the arbitration, because it has significant bearing on our finances. And as we all know, we are not in normal times as far as revenue is concerned. The matter that I raised was to draw your attention. Once you are not aware that they have filed an arbitration claim of $320 million, I'm only informing you in advance, so that God willing, when you are gifted with that opportunity, it should be one of the issues before you. Because once they have made that claim, it is clear that they are taking steps to extract that from our very dry pocket as well. Thank you.
Is that matter still pending?
Yes. Because in fact, they have filed a claim in November, and that's why I'm informing the incoming Attorney General about it.
Well, be guided of the fact that we cannot be commenting on the matters of judice.
I take you from the chair.
Thank you very much. It's done the last question.
Congratulations, Doc. Doc, We've been talking about oral, special prosecutor, and what have you. People want to find a very quick way in administering criminal trials in this country. The immediate past Attorney General came to the floor, introduced an amendment to Act 30. It went through first reading, second reading, and consideration stage. But it could not see the light of day because we could not take it through the clause by clause and also the third reading. Would you consider reintroducing the bill to enable your office to take the necessary steps in the reforms proposed therein in our criminal justice system? Thank you very much.
Yes, Mr. Chairman, thank you. If the honorable member is seeking to know from me whether in terms of the scope and substantive content of that bill, it will be introduced as it was, my answer is no. The reason is because I disagree fundamentally with some of its logic. For instance, the whole idea that preliminary applications are being used to delay and stymie the conclusion of trials, I disagree with fundamentally. I think that lawyers should be allowed, if there are technical issues that judges have overlooked, they should bring applications, as many applications as they can. It is incumbent upon the judiciary to dispose of those in an expeditious manner so that the substantive trial can proceed. To bring statute, to basically try to constrain lawyers, from filing preliminary applications. Some of them are, fundamental in terms of seeking to do right by the law and procedure under Act 29 and Act 30. So I disagree fundamentally with it. I will take a critical look at it. I took part in the consideration, but I had fundamental issues with it. I'll take a look at it and see if it should be ever tabled at all, or that the status quo ante remains.
Thank you very much. Your submission is in time.
Matters are specialized areas. There's no in-house expertise, to handle them. And sometimes they are also complex. And if the jurisdiction is not Ghana, and you're not familiar with the law and practice of the seat of the arbitration, you have to be careful that you take, you have to be careful in not disregarding any advice to bring in lawyers from that jurisdiction in order to be able to conduct the case very well. So yes, I will consider the use of in-house expertise, but it's not exactly true that they use in-house lawyers throughout. The Attorney General kept saying that, but during the transition, we had evidence that they consistently paid foreign lawyers millions of dollars to do cases for this republic. Thank you very much. Mr. Chairman, I agree with the honorable member that the jurisdiction of the Supreme Court is very wide, and he has already enumerated them, so I don't need to repeat them. But you can deal with the issue of the caseload in two broad ways. One is dealing with them through the adoption of very efficient mechanisms of deciding cases. All right, so I'll give you an example. In the United States Supreme Court, which has only 9 members, okay, and they have operated with 9 members for over hundreds of years. The United States of America is bigger than this country. Cases come from the district court all the way through the various circuits Okay, and their circuit costs, like, the 9th circuit, the 6th circuit, and so on, are very big. And sometimes, if there's a federal element in a state matter, it can emanate from a state Supreme Court to the United States Supreme Court. And yet they still have only 9. You know how they deal with the cases efficiently? The judges, for every case that is coming, they look at the brief, and if they have already decided the matter, they simply let the registrar write a brief note, and it says set denied. All right? Set denied means that the justices are not interested in looking at this matter. And it's a very well-known procedure. So if you are a practitioner before the United States Supreme Court, you have to be very, very good at distinguishing cases to be able to convince them, to take up, your matter. So if it comes to them and they let their research, what they call them the clerks will review, they'll go to conference, and then they tell the registrar, right, set denied. That is it. You're not going to waste the time of the court by coming to appear before the court and call, for the case to be called and so on. I think that we should adopt very efficient, procedures like that. Because sometimes people take very frivolous cases, frivolous appeals to the Supreme Court, for instance. I remember once I was before the court, and then somebody brought an appeal that had to do with the fact that he, the lawyer, was not there when a decision was granted against him. So he took this appeal all the way from the High Court to the Court of Appeal and then to the Supreme Court. And the Supreme Court was empaneled to hear him. It was so frivolous. So they gave it to him by way of speaking. They gave it to him that morning in front of all of us. So we should have procedural mechanisms that will sieve out all the frivolous appeals so that the justices are not burdened. One way is also to increase the numbers. But then the court itself, through the the exercise of the administrative powers of the CJ, should divide itself into specialized divisions, all right? So you can have the Supreme Court Constitutional Division, and you have 5 justices very specialized in constitutional law who will quickly deal with these matters, okay? And so on and so forth. Of course, you have some of them who are experts in criminal law, like my former teacher, Justice Henrietta Mensah-Bonsu. She could lead a panel of justices who will be dealing with criminal appeals. So specialization may make the court more efficient, and then the burden on the court will be reduced. But that would mean, for instance, that instead of 11, we may have 15, so that 5 each, could deal with, because the court is properly constituted with the Chief Justice and 4 other justices, of the court. That is what I would say for now.
I don't even have the locus to be asking any question, but something is very dear to my heart, and which I must pursue. I remember in the previous Mills Mahama NDC administration, in which you served as a Deputy Attorney General, the state lost a number of international arbitrations and local cases at huge cost of the state. An example is the Balkan arbitration, in which about 13.5 million was awarded against the state. My only question is, how are you going to avoid the occurrences of these situations? Thank you.
Mr. Chairman, I have previously answered this question, but I think I would indulge and then say maybe as closely as possible to the answer that I gave, which is that we will do our best in the department to ensure that we negotiate well as far as the agreements are concerned. We do not take steps to abrogate when we know that the state will incur liability. We make sure that public officers, who are involved in these transactions, do right by the law. So when we act right, we will win at the arbitration. It is the arbitrary termination or wrongful terminations, sometimes because the public officer that is engaged in that conduct, that is a public officer issuing the letter of termination, does not or is not mindful of the financial liability that will accrue to the Republic as a result of his or her conduct. I think that we should begin to also punish, such people when they, misconduct themselves. That is all that I'll say for now. So when they know the legal consequences will be adverse, they will be careful not to arbitrarily terminate and then bring about judgment debt.
Thank you very much. Any further question?
I've always admired you for that. And I'm sure that as Attorney General, I don't know whether your fashion will change. But congratulations. But I have one important question for you. Ghana ranks 72 out of 180 countries in the 2023 Corruption Perception Index, indicating persistent challenges with the issue of corruption. What innovative and practical measures will you champion to strengthen the capacity of anti-corruption institutions in the country?
Thank you very much, Honorable Chairman. Just to let the nominee know that my fashion taste will not change as Attorney General.
The member.
The Honorable Member. I'm so tired. I'm reversing the cut. Yes. When it comes to the issue of corruption, as a country, we've tried various mechanisms, we've tried various institutional measures. We formed commissions of inquiry. If you go back to our history, the Olenu Commission of Inquiry was into the sale of import licenses and the bribery associated therewith at the Ministry of Trade. For the lawyers around the table, you remember the case of Kenya versus the Republic. That case arose out of the Olenu Commission of Inquiry report. So using commissions of inquiry has been one of the things that we've used to fight corruption. Of course, constitutionally, you remember that SRAJ is also another institution that has an anti-corruption mandate. And at the beginning of the Fourth Republic, you remember very, very well the work that its first chairman, Emil Short, did with, high public officials appearing before the SRAJ. Some of it went to the Supreme Court in challenges, and there are decided cases dealing with the procedures that were adopted and so on. We've had, various other bodies that we've used and institutional measures that we've used to fight corruption. So, Mr. Chairman, there is no shortage of institutional measures, all right? When you set up institutions or you create institutions, and by the way, institutions are the rules of the game in the society. So, the norms, the practices, the hardcore statutes and so on are all, institutions. So there's no shortage of institutions in this country. But sometimes implementing the measures is where the problem is. So I'm going to give you one example. So we have the Whistleblowers Act, right? The Whistleblowers Act is supposed to, give whistleblowers who may be near the action as far as corruption, bribery and corruption is concerned, to provide the requisite information to law enforcement agencies to take action. Okay, and when I was Deputy Attorney General, we had situations where a whistleblower gave us information, and then we did the investigation, and eventually we recovered over $30 million Ghana cedis. That is the record that is not being talked about. We recovered over 30 million Ghana cedis, which was which was paid by those who were involved. But because of confidentiality reasons, I cannot mention those who was involved. So, for instance, the plan which I have discussed informally with His Excellency is for us to have a whistleblower agency in every district, and then to publicize the procedures, create a hotline where if there is wrongdoing that is happening, okay, we will, that hotline can it can be the regional chief, the chief state attorney, being called and, a report being made so that he can then, with the police and the other investigative bodies, investigate and then, ensure that the wrongdoing which is being reported, the evidence of it is gathered and so on. So in every district, we'll implement it and then have a hotline that can be used to report, information about corruption. So the anti-corruption institutions, okay, should not be thin on the ground or centered in Accra and, depriving ordinary people of the opportunity to report, acts of corruption. And of course, under the Whistleblowers Act, when you report and there's a recovery, you are entitled to 10%, a percentage. And I remember that in this case that I've cited, the whistleblower was actually paid. The Honorable Atachia, eventually, if you want to, cross-check what I'm saying, you can ask him. The Honorable Atachia represented the whistleblower in his pursuit of the 10%. We agreed to pay when MPP took over. There was some hanky-panky, and then the whistleblower had to go to court. So that is an incentive, for whistleblowers to report. So, Mr. Chairman, we need to operationalize and make sure that the anti-corruption institutions, the anti-corruption measures permeate all the way to the local level. That, during the revolution, of course, there were excesses. But during the revolution, the Honorable Cletus Avoka is here. Those days when we were young men in Bolga, they were the revolutionary lawyers. And of course, the reports, they caught many people, civil servants, public servants, engaged in bribery and embezzlement. And they were tried by the tribunals and in some cases by the courts. In some cases, they were sacked. I think that those radical measures need to be reintroduced. Thank you, Mr. Chairman.
There are no further questions. Congratulations.
Congratulations.
Thank you, Mr. Chairman.
Chair, I want to take my respected colleague, learned colleague, to his CV, page 1. The page 1 of your CV has no biodata of you, so can you graciously provide us with your biodata?
Ayine, and I was born on the 6th of January, 1966. To Mr. Ayine Atenga and Madam Ateni.
What's your address, please? Your residential address?
My residential address is number 3 Kofi Annan Avenue, North Legon, Accra.
Your postal address?
P.O. Box LG 70, Legon, Accra. I still use my address, the address that I was using when I was a lecturer. It's allowed because I'm still associated with the University of Ghana.
Now, have you paid all your taxes to date, or have you made arrangement to meet those obligations to the state?
Mr. Chairman, actually I have a credit of 470 cedis that the Republic owes me. In other words, I've overpaid. On my tax, clearance certificate, which I can present to the committee.
Do you immediately remember how much tax you paid to the state last year, for which you have gained this credit?
No, please.
If given the opportunity, would you be able to furnish this committee with the amount of tax you paid to the state in the year 2024?
Yes, Mr. Chairman. I can furnish the committee with all my tax record, including those from my law firm. I'm very, very, very up to date with my taxes. I don't joke with it at all.
Chair, I'm very specific in my dealings with my respected colleague. I'm asking about your 2024. I'm not talking about other matters.
Yes,
2024.
Yes, Mr. Chairman.
Very well. Chair, may I know from the nominee whether he ever represented Fidelity Bank as its external solicitor?
Yes, Mr. Chairman, I've represented, and in fact, I'm still representing Fidelity Bank as its external solicitor in a case that I filed in the High Court for damages for defamation.
Are you on retention?
No, I'm not on retention.
Are you also a solicitor for the Electricity Company of Ghana?
No, I'm not.
Have you ever been a solicitor for the Electricity Company of Ghana?
Yes, I have been before. I've represented them, the ECG, in one matter, which was before the High Court, which case has been disposed of. And then also, I was actually hired by an English law firm called Omnia LLP. That was hired by ECG as their lawyers before the London Court of International Arbitration, and I was hired as a Ghanaian law expert, and I appeared before the tribunal on behalf of ECG.
Very well. Was that case in respect of the PDS matter?
Yes, please.
Very well. Leonard, so how was the outcome, what was the outcome of the PDS trial?
Mr. Chairman, let me make it clear. I was lawyer for ECG, that is Electricity Company of Ghana, not PDS. But the dispute was brought by PDS. I want to make it clear. I mean, I know why I'm saying
Chairman, so let's help ourselves with respect. So PDS sued the Electricity Company of Ghana.
That is correct, Mr. Chairman.
Right. So ECG then became a respondent in the matter.
That is so, Mr. Chairman.
Yeah, so for the records, you were one of the attorneys for ECG.
That is so, Mr. Chairman.
Very well. So having landed on that point, I shall proceed to ask you, what was the outcome of the said arbitration of which you were counsel for ECG, please?
Mr. Chairman, we are expecting the award in May. Everything that I was supposed to do as counsel has been done, except that my fees are outstanding.
You mean part of your fees? You mean part of your fees is
yes,
outstanding?
part of my fees.
Yes, so because you were paid some, and your later invoices are outstanding. That is true.
That is so.
Yes.
Yes, but let me put it on record that I was on the side of the Republic. I want to put this on record, that I'm on the side of the Republic. The Republic is the sole shareholder of PDS, of ECG, and I sided with the Republic. I was invited by PDS to be their lawyers. I declined for ethical and political reasons. I want to put that on record.
Chairman, I would want to plead with the nominee that much as it is his desire to provide additional information, I would plead with him to limit himself to my question, because I do not want to prolong matters. If you bring in other matters, then you would lead me into asking. So I want to make it as short as possible. Is that okay?
That is okay, Mr. Chairman.
Now, Honorable Nominee, can you tell this court within which you acted as solicitor for ECG?
You mean in respect of the...
In respect of the arbitration, the PDS...
the arbitration has been going on for... Mr. Chairman, the arbitration has been going on for the last, I think, 1.5 years. Yes.
Really?
Yes.
We are in 2025.
That is so.
Is it your case that...
It started way before 2024.
Yes, so that's the clarification I want you to provide. Were you hired in 2018?
Now, in 2018, maybe, Mr. Chairman, he's confusing two matters. There was another matter, that is ASG versus ECG. That is all, well, that's the short name of the company is ASG, All Services Group. All Services Group and, ECG, okay? So that arbitration was the first time that Omnia LLP requested my services, and then they hired me. And because I performed, to their satisfaction, in the PDS matter, they came back for me.
So when did the PDS sue ECG?
Mr. Chairman, I can't remember off the top of my head, but I can provide the committee with the accurate information.
I can give you the opportunity with the leave of chair. I know you did a case with your respected junior, whom you've trained so well. I watched him at the Supreme Court with a lot of admiration, and one must compliment him for his great advocacy. He's right behind you, since most times he was holding your brief. Can you, with Mr. Chairman's leave, take the date from him? He's behind you. If the Chairman will grant leave.
No, I think the witness is under oath. We cannot allow another person to interfere. So he promised when given the opportunity, he will let you have the date. So we take the witness words.
So, thank you, Chairman. Thank you. So, Leonard, in taking up the case, Electricity Company of Ghana being their counsel, you believed in their case, didn't you?
Very well, Mr. Chairman. I would never take a case. My juniors know that. I won't take a case unless I believe in the merits of the case.
And you believe that your client had done nothing untoward in its decisions leading to the termination of its contract with PDS?
Mr. Chairman, the witness really provided the answer that he will never take a case unless he believed in...
And additionally, we are still expecting the award. So I wouldn't be permitted ethically to start discussing the merits of the case.
Chairman, you and I are practitioners, and I will respect those barriers. I'm not going to ask you to narrate to us those details of the case. All I want to ask you is that you believed in the merits of your client's case, to the effect that, in your view, your client had not done anything wrong in the handling of its contract.
That is correct. That is correct, Mr. Chairman.
Thank you.
Hold on, Dominic. Honorable member, by the indication from the nominee, the case is pending award. Is that not so? So
that is so, Mr. Chairman.
So it is a matter under determination, and by law, can we be going into the merit of that particular matter, whether you believe or you don't believe in it, since it is pending a judicial determination?
Chairman, I appreciate your intervention. I would humbly plead with you one more time to allow me to flow. I would not cross the barrier, and I believe that you've heard me loud and clear. Now, honorable nominee, and let me say to you that though we have political differences, I respect you for your stance in a lot of matters of national discourse. And without prejudice to any member of the majority caucus or any member of the NDC, you know that you are the only person who has a picture with me, and that picture is in my office. It's there on a purpose. You know that. So I laid that foundation to ask you this other question that is coming up. You took this case with ECG, well aware of the politics of the country at the time, weren't you?
That is so, Mr. Chairman. I operate within the political, legal context of this country, and I'm always aware of the political dynamics, and I consult widely before I do what I do.
So the point I want to make is that you were aware that where you stood in the political space, you were against the tide in taking up the ECG case.
I didn't think of any tide. I thought about the interests of the state of Ghana.
I agree. And that is why I'm celebrating you for that which you did. That politically, the tide was against the government of the day. But here you were, because of your professional stature. And I was happy you made reference to a third-party legal firm that actually spotted you and pulled you out of the lot to be the representation, the attorney for ECG. So that's what the point I want to make, that politically the tide was against you. Would you agree?
I was not conscious of any tide. I wasn't swimming against any tide. I just took a professional decision to agree to serve as counsel in this matter. And the ECG is owned by the Republic, owned by the state. It's a limited liability company with its own board of directors and so on. I didn't think about the political implications of representing ECG, but I knew that the politics around PDS was not, because I also believed in the fact that there was wrongdoing on the part of PDS, and I wouldn't accept a brief, from a company that I believe was in the wrong in respect of a transaction.
So you are saying that ECG is a limited liability company with its own board. So it's a separate corporate entity from the state, though the state is a sole shareholder.
Yes, Solomon versus Solomon.
No. Yeah. I just want to ask that for emphasis.
Yes.
Therefore, the conduct of its board is completely independent from the state, correct?
That is correct.
So if, as Attorney General, you are to advise the state in a situation where the minister, the sector minister, wants to, through a public statement, dissolve the board, would you find that to be appropriate?
Yes.
Please,
yes.
kindly explain.
Yes, Mr. Chairman, because the appointing authority has changed.
Get my statement in question, my question in context, so that you don't have what I'm saying. The question is,
yes,
since you acknowledge through Solomon versus Solomon, they're saying that the body, the company is an independent, institution separate with its own board. I'm asking whether a sector minister will be right in issuing a statement to dissolve a properly constituted board of that entity which you acknowledge as a corporate body with all its rights engraved in law.
Well, we can haggle with the form that it has taken, but that is notionally equivalent to a resolution of the shareholder dissolving the board.
Okay, so let's go a bit into company law, since you are introducing that. So, my basic understanding of corporate law is that the shareholders have such rights to take decisions on the appointment of the directors of the firm. And once those directors are appointed, they assume their independence, of course, subject to the articles of incorporation and what the shareholders will so direct. They may have their own vision. Are you saying, therefore, that by virtue of the state being the sole shareholder, without convening an AGM, the sole shareholder, as represented by a sector minister, can sit in an office and issue a public statement to dissolve the board, and that would be sufficient in law? I just want to know from you.
Mr. Chairman, that is why I said we can quibble about the form that this has taken, but a sole shareholder cannot hold a meeting with any other person but itself or himself, right? That's what it is meant by sole shareholder, right? So if I were to advise the minister you're talking about, I would have drawn up the resolution, right, and served it on the members of the board. That by this resolution dated the 13th day of January 2025, the board is hereby dissolved. And that would have been very, very appropriate. Okay, so the form that it took is probably what you are quarreling with. Maybe if it is in the form of a letter, without any reference to the shareholders' rights and so on and so forth. That is the, but I mean, that is what you are quarreling about. But as Attorney General, I'll advise that the right thing be done.
Chairman, I think one of the things for which the nominee has earned the respect of many colleagues is his position on the law. And let me say, I appreciate your very candid view on this. And I pray that you will walk the talk and ensuring sanity as we get along, because this, our politics, it is party go, party come. And we need to assure those who take up responsibility in running state institutions. Now, I will proceed to my next observation about you. None of us here can be perfect. There are times that we lose it, and there are times that we get it all well. Have you ever felt frustrated as a lawyer in any matter that you've handled, whether in your private practice or in being a lawyer for the states, in your previous life as a deputy attorney general? Was there any point that you felt very frustrated in any brief that you handled?
We get frustrated and exasperated on a daily basis. Sometimes it may be coming from the clients. Sometimes it may be coming from the courts or tribunals that we appear before, and so on. Yes, so I have been frustrated before, but that is normal. It's part of, it's part of life.
So, have you ever felt disappointed in an outcome of a case, whereupon that led you into some public outbursts?
Mr. Chairman, I don't know what the honorable member is driving at, but if you realize, okay, I don't run public commentaries on cases that are handled. As a matter of, the practice and tradition of my firm, we don't run public commentary unless the matter is political in nature and there's a need for some clarification because of the politics inherent in the matter. But as far as my commercial practice is concerned, yes, sometimes I lose cases, but I don't run commentary on them publicly.
Chairman, please, I claim your attention for the specific language I'm using for my question. My question is, have you ever been disappointed in the outcome of a case, meaning a final judgment in a case you did, whereupon you made some public statement? I'm not talking about running commentaries on a case you do. I am asking whether you recall any public outburst emanating from a judgment in a case that you did.
Mr. Chairman, I cannot recollect. So if I cannot recollect.
Honorable Dominic Ayine, in the Woyome case, where my Lord Ajet Nassem presided, you, the media, reported you to have said that is the submission of no case, where the judge ruled in favor of Mr. Woyome. In other words, his application that there was no case to answer was upheld, and your opposition to that application was rejected by the court. The media reported you to have said that the judge had made up his mind even before the case. If that report by the media is correct, on hindsight, Do you think that you were right?
Well, Honorable Minority Leader, the witness indicated clearly that he doesn't run commentary. He cannot remember. But you keep on asking about. So the witness will want to answer. Proceed and answer.
Mr. Chairman.
Council, hold on a second. Chairman, I've used the word plead with you for the umpteenth time. Chairman, please, stop it. Some of our colleagues are expecting a certain level of conduct from us. I beg of you, let him proceed. Let him proceed, please. Let him proceed.
Mr. Chairman, thank you very much. I think context is very important. Context is very important. I do recall that when the ruling on the submission of no case was granted in favor of Mr. Woyomi, I was not directly handling the matter. I was actually supervising the current DPP and a team of lawyers to handle the matter. But then the judge, in his ruling, took a swipe at the Attorney General. That is my boss. He took a swipe at the Attorney General because this was a case between the Republic and Mr. Woyomi. So he took a swipe at the Attorney General. We read the ruling in chambers. We wanted to ignore it, but then lawyers were called who were then running adverse commentary against us in the matter. And so we took a decision in chambers that we needed to respond and to explain. And Mr. Chairman, there's a lot that I know about a judge that you don't know. So don't open a Pandora's box.
Chairman.
Thank you very much.
Chairman. Of course, I recall former U.S. Defense Secretary Donald Rumsfeld come up with this saying that there are known unknowns and there are unknown knowns. I'm sure that is the area you're trying to venture into. However, the unknown knowns which you want to refer to are not a matter that the public became aware of because you did not want to put the unknown knowns out there. That is why you didn't put it out there. I am only interested in the fact that the ones that you decided to put out there. And that is where I seek to ask you a question on. You've explained that it was in context, and I think that's fair enough. I wouldn't belabor. But let's also move to another point. The Supreme Court. There came a time where the Supreme Court made certain pronouncements, which I'm sure you were not too pleased with said pronouncement, and that resulted in some comments by you, and the Supreme Court was not happy, and eventually the gentleman in you, as we all know, you conceded and put matters to a peaceful rest. What have you to say to young practitioners who will be dissatisfied with Superior Court decisions, given your own experience in what happened?
Mr. Chairman, thank you very much for the question. Once I am approved and sworn in, I will be the leader of the bar. And I'll set a very good example. I think even in private practice, you would admit that I am an example. I've never been engaged in any unethical conduct in my practice. So I will lead by example, and that will be from day one. So I wouldn't encourage any young lawyer to, out of frustration, take the judiciary to the cleaners. Because remember that I am not only Attorney General, Principal Legal Advisor to the President, but I'm also the Minister of Justice. I will be the Minister of Justice, meaning that the justice sector will be under my ministry. That will be the principal, apart from the Attorney General's department, to be the principal sector in terms of policy and in terms of law that I will be superintending. And so I would want to have, a very good relationship with the judiciary, a good and respectful relationship with the judiciary.
Chairman, we have become aware of an executive instrument dated the 9th of January 2025. And this executive instrument takes its strength from Section 11.3 of PNDC Law 327. It lists a number of ministries. Conspicuously missing is the Ministry of National Security. Now, in the Securities and Intelligence Act, there is a provision for the creation of the Ministry of National Security. Going in as the Attorney General, would you advise the President to amend this EI to reflect this new enactment that Parliament has passed? Because it appears that His Excellency solely relied on the PNDC Law 327 without paying due attention to the Securities and Intelligence Act, which Parliament passed recently.
Thank you, Mr. Chairman. And I have, previously had to have, discussions on this matter. But in terms of the hierarchy of laws, of course, the Act supersedes the executive instrument. And once the Act provides for a Ministry of National Security, and the principle of law is that Parliament does not speak in vain. We will, take a second look at it and then advise the President accordingly.
Chairman, kindly stop this act.
Well, honorable members, I think there should be a ceiling on a number of questions that the leadership is also supposed to ask, so that we don't go to town, we go straight to the point. So at our meeting, we need to take a decision as to the number of questions that leaders are entitled to ask.
Chairman, indulge me. Chairman, indulge me. Chairman. Chairman.
Chairman. We should allow a free flow of proceedings. Okay? I beg of you. Honorable nominee, in Article 181(5) of the Constitution, that provision in the Constitution received some judicial pronouncements. The very first one, I believe, the Clomega case, Clomega versus the Ghana Port and Harbors, where the Supreme Court had an opportunity to make some pronouncement. I believe that the court made some consequential orders to the effect that Parliament would have to ensure certainty in that provision of the Constitution by enacting a law to regulate 1815. It's been long overdue. We don't have a law yet. In the Sebe Yabwa case, the Supreme Court even distinguished the law further, made a clear path, and said that even in situations where the transactions involve state entities with its own board, it wouldn't be considered as part of 1815. However, they still felt that Parliament has failed in enacting a law to regulate 1815. Now you have the opportunity. Can you assure the country that
he has the opportunity, or is going to have the opportunity? Or if he gets the opportunity?
Yeah. Chairman, I think this question on Article 181,
Your leader is speaking.
I sought leave from the chairman.
And what about?
I sought leave.
Is it in relation to what I am saying, that now you have the opportunity, or now you are going to have the opportunity?
Bringing a very important matter to your attention.
Is it on that issue?
I'm bringing a very important matter to your attention. That the Speaker set up a committee on Article 181(5), and that report and bill is ready. That's for information.
Thank you very much. So, leader,
and Mr. Chairman,
your wedding, now you have the opportunity. Do you still stand by it?
Mr. Chairman,
now that he's going to be given the opportunity?
Yeah, just to add to what the Honorable Patrick Boama has said.
Honorable nominee, hold on a second. Let me handle the matter with the chairman. Chairman, let me flow. Okay?
You have been flowing on and
Let me finish.
Your statement is as if he has been approved.
Chairman.
Now the Attorney General. Meanwhile,
Chairman.
we are in the vetting process.
Chairman, I'll go back to the question. Honorable nominee, now you have an opportunity back to the Attorney General's chambers. Will you assure us that steps will be taken to enact a law to regulate 1815?
Thank you, Mr. Chairman. Just to add to what the Honorable Patrick Boama has said in answer to your question, Mr. Speaker set up a committee on the side of the then minority. I was a member with the Honorable Dr. Kaisel Atufosin, and then the Honorable Elizabeth Ofosajari. And we came up with a bill. I'm a co-author of that bill with the Honorable Joe Gatti. And the bill was supposed to be laid in Parliament before we rose. But because of certain developments that took place, the bill has not been laid. I'm very satisfied being an author of the bill. We took, the Honorable Patrick Boama and I took part. We even had a stakeholder consultation, and the bill is ready. So it was Parliament's bill and was being sponsored by the members of Parliament from both sides. If Mr. Speaker still has that intent, I will allow that process to flow to its logical conclusion. Otherwise, I will adopt it as Attorney General, and with the backing of the Minister of Finance, Dr. Atufo, will bring the bill back to Parliament, and then it will start the process of first reading through to passage. So that is what I can assure the country.
You become aware of the oral.
Yes, Mr. Chairman.
In your view,
oral was an integral part of our campaign message.
Right.
And our campaign, I was a surrogate campaigner for His Excellency John Dramani Mahama, and he's committed to oral, and I'm committed to it as well.
Right. So, good. In your view, do you see this committee as a constitutionally empowered committee? You think that it has a constitutional backing or any statutory backing to have this committee in place?
Well, if by constitutional backing, there are two ways by which the Constitution would have backed oral. That is, if it was specifically stated in the Constitution, such as the Commission on Human Rights and Administrative Justice, which is not the case, or if the Constitution provided the framework, the constitutional framework, for the establishment of a body called the Operation Recover All Loot. But I think I stated quite, clearly, and I don't know whether you were in the room when I gave the answer, that one of the fundamental principles of the Constitution is the principle of accountability. And oral is about exacting accountability. And I think that my senior colleague and partner, the Honorable Mahama Yarga, added substantive, sense to what I did, with the answer I gave, by making a reference to Article 41F of the Constitution, and the obligation on all citizens, to take steps, to protect public property and to avoid waste of public, funds. So I think that oral is not unconstitutional. Oral is not illegal. Just because it was not set up by an act of Parliament does not necessarily make it an illegal body. So it has constitutional backing in terms of the fundamental values of the Constitution.
Chairman.
Well, before you come in, I recognize Roxanne Dafamokbo on point of information.
Grateful to all the political parties, the reps of the independent candidates, as well as our friends from the development community, civil society, and others who are here, as well as the media. On the agenda for IPAC, we have two main items. The one has to do with accreditation and information on collation centers. And we've sent you the information on the collation centers. I believe all the parties, reps of the independent candidates, have received this particular document. We want to discuss the two issues together. When we finish, then we open the floor for the discussions to take place. We are beginning with the collation. The Commission has appointed collation officers at the constituency and regional levels to assist the returning officers and the regional collation officers in the performance of their functions. Per CI 127, Regulation 23B. CI 127, Regulation 23B allows the Commission to appoint officials to assist the returning officers. In the spirit of that, the Commission has appointed these collation officers to work under the supervision of our returning officers. So the collation officers will work under the supervision of our returning officers, and as all of us may be aware, The returning officers also work under the supervision of the district officers. The Commission advertised the position of collation officers in the newspapers. 16th August, in the graphic, 16th of August on page 12. We advertise for applicants with backgrounds in statistics, accounting, finance, and other related quantitative areas to apply. A team from the head office of the Commission, including the executive commissioners and commission members, directors, and our officials in the regions, as well as officials from the Ghana Statistical Service, constituted the interview panel. Those who were selected are well qualified for the job. The Commission will undertake training for them to ensure that they deliver on election day. The reason why we engage them basically has to do with to enhance the integrity of the collation. Their main function is to do electronic collation of the polling station results for both the presidential and the parliamentary on an Excel format provided by the Commission. They are going to work side by side with our returning officers, but independently. The ROs will do the manual collation and compare with that of the collation by the collation officers. And again, they work under the supervision of the returning officers. Collation at the constituency centers begins after the close of polls at the polling stations at 5 p.m. The Commission provided its officers some guidelines for places that are suitable as collation centers. Number one, they must be in a secured neighborhood. They must have entrance and exit points. They must be spacious. They must be spacious and walled. They must also be well-lit centers. Additionally, our officers were supposed to collaborate with the district police commanders to ascertain the qualities of these particular centers. As a result of that, some of the centers that were used in 2020 did not meet the qualifications for 2024. Or for the regional collation, all of them will take place at our regional offices. So the collation at the regional level in the Volta region will take place at Ho. In Ashanti region, it will take place at our regional office in Kumasi. In Greater Accra, our regional office in Sapema. So that's what is going to happen. The national collation will also take place in Accra at a venue to be communicated to the parties and agents of candidates very, very soon. Now, in terms of accreditation, political party accreditation at the collation centers, political parties and presidential candidates will be given accreditation for 2 agents at the collation centers, at the constituency collation center and the regional collation center. So political parties, presidential candidates will be given 2 agents. So at the constituency collation center, political parties will have 2 agents. The same applies to the regional collation center. Domestic and international observers will also be given accreditation at the constituency collation and the regional collation centers. And here again, only accredited persons and organizations will be allowed into the collation centers, both the regional and the constituency. The national as well, if you are not accredited, you will not be allowed. The media will be allowed to cover the accreditation, to cover the collation at the constituency, the regional and the national levels. But the number of media houses to be allowed to cover these activities, the EC is still in discussions with the Ghana Journalists Association and as well as the Ghana Independent Broadcasters Association. But what is certain is that the media will be allowed to cover the collation at the constituency, at the regional and the national levels. Political parties and presidential candidates will have 2 persons at the National Collation Center. However, they will be given permission for 4 persons, but only 2 will be allowed at a time at the National Collation Center. So the parties, the presidential candidates will have 4 representatives. They will be given the opportunity for 4, but at any point in time, only 2 will be allowed in the National Collation Center. And to continue, the Commission's attention has been drawn to a memo written to political parties and some of our printing houses, informing them about shortfalls and some discrepancies with the ballot papers sent to 2 of our regions, the Bono and Volta. The said memo is circulating on social media. We wish to inform our political parties and all the observers here that it is part of the transparent and accountability mechanisms of the Electoral Commission. Because the Commission directed its regional and district levels as well as the Commission staff to review and verify ballot papers received to ensure their accuracy and to guarantee that they tally with the ballot statistics provided to the printers and political parties. This is a standard procedure of the Commission. It is important to note that this additional verification unearths any issues with the ballots and enable corrections to be made ahead of the elections. As stated, this is a standard procedure and it is to ensure that all ballot papers are accurate and intact on the election day. This is a further layer of accountability that the Commission employs in the printing and distribution of ballot papers. The essence, as noted, is to ensure full accountability of the ballots and to make sure that the ballots sent to the regions are accurate. It is important to note that in the spirit of transparency, the Commission notified the political parties and presidential candidates to enable them inform their agents to observe the reprinting of the ballot as well as the destruction of the faulty ballot papers. The question is who discovered it and who is requesting for a reprint. The Commission has nothing to hide. Why would the Commission inform political parties in writing if it has something to hide? It is the Commission staff at the regional level that discovered and reported back to the Commission. It is the Commission that ordered the reprinting and informed the political parties and the presidential candidates. The Commission had nothing to hide. This is the procedure in place, and it is the Commission which is requesting a reprint of the shortfall in the presence of the agents, not any political party. For the benefit of the general public, similar shortfalls and discrepancies were discovered and reported back to the head office by our regional directors. The shortfalls occurred in Greater Accra, Western North, Upper West, Western and Bono East regions. So the Volta region and the Bono region are not the exceptions. The political parties were also informed in writing and the reprinting was done. Why the noise about the shortfall for only the Volta region? If the Commission had anything to hide, it will not transparently call for a reprint of ballots to make up for the shortfalls. The Commission urges the general public and especially our political parties to disregard acts of mischief by persons whose only objective is to malign the Commission and sow seeds of mistrusts and doubts. The memo in circulation demonstrates the Commission's resolve to operate above board and in a transparent and accountable manner. We entreat our political parties and the general public to carefully read the memos from the Commission which may find their way onto social media so that they are not swayed by persons whose sole agenda is to cause fear and panic and tarnish the image of the Commission ahead of the 2024 presidential and parliamentary elections. For the information of our political parties and the general public, we sent earlier letters indicating the shortfalls in some of the ballots for some of the regions. And I have a letter here showing 22nd November, 40 and shortfall of ballot papers which were sent to the political parties and printing houses. And the latest one occurred on November 28th. So this is a clear indication that the Volta and the Bono regions were not the only exceptions. It's a standard practice we have adopted as an institution that anytime the ballots are sent to the regions, we do another check. And if the checks reveal that there are any shortfalls, automatically we get into action and we print them to make up for the shortfalls. And we think that this is a quality practice which must continue. So we are very grateful for your attention. Now we will give the opportunity to the parties and the agents of the presidential candidates to ask questions or any concerns they have. Thank you very, very much. Mr. Tete, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Teta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Cheta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Cheta, you can now take over. Thank you, John. Ask questions or any concerns they have. Thank you very, very much. Mr. Cheta, you can now
A key actor during the enactment of the OSP because of where I came from.
You were also a key advocate for the law to be enacted to enable the Office of Special Prosecutor have the legal powers to proceed with its work, correct?
I don't know what you mean by a key advocate. I took part in the lawmaking process. Go back to the Hansard. My initial position was that it was an unconstitutional body because it was, to me, violative of Article 88 of the Constitution, because we're taking the constitutional powers of the Attorney General and giving it to another person and seeking to say that the Attorney General that person should be autonomous or independent of the Attorney General. And I said, no, those prosecutorial powers inherently belong to the Attorney General, and no one can take them away and then say that the person should be, ring-fenced in such a way that that person, should not be controlled by the Attorney General. I made very forcible arguments to that effect, and that is how come that there were provisions, the independence provisions were watered down at my behest. And of course, I was just a lone ranger at the time, but I'm no longer a lone ranger. I'll take a look at the law again.
So now, in view of that reasoning, which you hold so fair, and if I may have to repeat, you're saying that the establishment of the Office of the Special Prosecutor took away the prosecutorial powers.
Honorable members, preliminary comment doesn't take the form of questions to nominee. So I would plead with the honorable minority leader that if his preliminary comment is in the form of a question, then you can hold it. When we get to question time, then you look at the document and pose a question to the nominee. Thank you very much.
We know ourselves from practice, even though you are my senior at the bar. We cross swords in the case of the Henry Nana Boakye versus Attorney General, when you were the Deputy Attorney General. And subsequently, we found ourselves in the same aisle in the case of the Republic versus Dr. Kwabena Dufo and 8 others, when you were the initial attorney. So welcome. Doc, of particular concern to me is what I find in the your party's manifesto, which is titled Resetting Ghana 2024. At page 142, you have stated that you will establish the regional tribunals provided under Article 142 of the Constitution and pass a law to reintroduce the community and circuit tribunals, first established under the Courts Act 1993, Act 459, but abolished under the Courts Amendment Act 2002, Act 620. It is of concern to me because we all know what the tribunals did. In fact, the literature which captures the footprints of the tribunals is in abundance. And I have in my hand the African Watch report on human rights. African Watch report, volume 4, issue number 1. This is what it says about the tribunal. Dated 31st of January, 1992. This is what it says of the tribunal. That
the literature that we are quoting, what is the source of it? Who is the writer?
It is the report of Human Rights Watch, a human rights organization.
Human Rights Watch.
Yes.
From Human Rights Organization.
Yes, please. I have
Okay.
copies here. I can give the committee copies if my.
Well, I just want to know the source. Having mentioned the source, proceed to ask your question.
Okay. So it was abundantly clear that during one of the problems with the tribunal system was its disregard for human rights, such as refusing accused persons the right to even call witnesses sometimes. By the way, the jurisdiction of the tribunals was criminal jurisdiction. It was also noted for delays. It was also noted for delays. It had no regard whatsoever for the laws of this country, to the extent that as a result of the decisions of tribunals, our mothers were punished through caning.
Honorable member, question.
Mr. Chairman.
Honorable member, you are a lawyer.
It is very important.
Honorable member, I am asking a question. You are a lawyer.
Mr. Chairman, very respectfully, both of us practice at the bar.
Yes.
And so the question, Mr.
So,
Chairman, is...
So you know very well that the literature that you are reading doesn't take primacy over the constitutional provision relating to the tribunal.
Mr. Chairman, the constitutional provision relating to tribunal, Article 142, has to do with just regional tribunals. It is not related to district and community tribunals. So, Mr. Chairman, I need to give context to my question. So if you allow me, very respectfully, it's in the interest of the public.
Let's proceed and ask your question.
Mr. Chairman, so what the tribunal did, we are all aware. Indeed, when you look at the National Reconciliation Report, it captured extensively.
With all due respect, go straight and ask your question. You have laid enough foundation for your question.
Mr. Chairman, I think that if you allow me, the nation will be interested.
But you don't argue with the chair.
Mr. Chairman, this is not an argument, Mr. Chair. I'm only asking that you indulge me so I lay the right foundation and ask the right
You've been
question.
directed by the chair to proceed to ask your question, so do exactly the same.
In fact, in 2002, when the bill to abolish the district and regional tribunals was laid, one of the things that were captured in the Hansard, dated 18th March 2002, was that it was being abolished because of the breaches of human rights and also the cost associated with it. The Honorable Nominee, the question I want to ask you is that why do you want to reintroduce Why do you want to reintroduce something which is associated with the dark past of this country? Why do you want to reintroduce it? What is it that our ordinary courts, regular courts, cannot provide in terms of the criminal jurisdiction of this country that you want to revisit and bring back the tribunals? Why? It is manifesto.
Very well, very well.
I refer to it.
Because what I heard was, why are you saying?
No, you means the NDC.
So you are now saying, why is the NDC having in the manifesto to do ABCD? Then we'll all be clear.
Mr. Chair, unless you want to separate the nominee from from the NDC.
No, he's here as
the nominee is in the belly of
if
the NDC.
You're asking a question in relation to his party's manifesto, you said so. Leader asked a lot of questions in relation to the manifesto. He expressly stated that, according to your manifesto, this is what you are saying. But if you said, why are you saying this, then we are referring to the nominee before us.
Chair, I'm guided. I'm guided, very respectfully.
Nominee, may you provide your answer?
Thank you, Mr. Chairman. The honorable member is right that the strategic trust of the President's manifesto, or the NDC's manifesto, which is an expression of intent regarding what we will do, the set of policies, and measures that we will implement when we are in power, is one to reset Ghana. Now, resetting Ghana doesn't mean taking Ghana back to factory settings. It means correcting the things that, in our experience as a nation, we've come to realize that they are deficient and they are not auguring well for our development as a country. Now, talking about the public tribunals, the honorable member will note that in terms of Article 25(1), it is provided that justice emanates from the people and will be administered in their name, in accordance by the judiciary and in accordance with the Constitution. The internal logic or internal morality.
Leonard, with respect, which article were you referring to, please?
Article 125, Clause 1 of the Constitution of the Republic of Ghana.
May you read it? Yes.
Yes, Chairman, I was trying to...
Honorable nominee. Honorable nominee, you are asked to read something without a permission coming from the chair. Please.
Very well, Mr.
Honorable Minority Leader has opened that particular provision, so I believe he will read it and satisfy himself. Proceed with your answer.
Okay, I believe he wants to lay the context for a question. So, Honorable Minority Leader.
Nominee, please follow the instructions of the chair.
Yes, sir. Yes, sir.
Chairman.
Chairman, I don't know if Honorable Boa wants to usurp your powers. You are in the chair.
I'm the vice chairman of the committee, in case you do not know.
Chairman, when we try to push, we get calls from your own side, we are in this together. I do not want to also get a certain impression that the chairman, in an attempt to assert himself, would want to do things to undermine this very process. In all humility, since morning, I keep using the word, I beg you, I beg you. The nominee made reference to a constitutional provision to make a point. And I'm saying that not all of us are lawyers. Not everybody here is a lawyer. And I say, can you read the provisions and explain your point? Then you come and say, yeah, but I am here with him.
Honorable members, the question is coming from Honorable Bafo. and answers are being provided by Honorable Bafo. If minority leader wants to ask a supplementary question, at least he should allow the witness to complete the answer, but not to interject to say that read the constitutional provision without even the attention of the chair.
Chairman, with your leave, I pray that the nominee, as he references Article 125, he should read it in full to situate the argument rightly. Thank you so much.
Well, the nominee even quoted the 1251 verbatim, but you may go ahead and read it.
Thank you, Mr. Chairman. Article 1251 of the Constitution, that is clause 1 of the Constitution, says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, who shall be independent and subject only to this Constitution. I think I paraphrased it very accurately. And I was on the point that the internal logic of the laws, the PNDC laws establishing the public tribunals, was to ensure the participation of ordinary citizens in the administration of justice. And that aligns fully with the substantive content of Article 125, Clause 1 of the Constitution, because it says justice emanates from the people. In the context of Article 125(1), the judiciary is the organ of state vested with the power to administer justice. And if the honorable nominee who asked the question, the honorable member who asked the question would care to look at Article 142 of the Constitution, which he referenced, all right? In that context, in the peculiar context of Article 142, the judiciary is defined to include the regional tribunals. What he left out is Article 142, I think, Clause 3, who says, and such other courts and tribunals as Parliament may by law establish. All right? So, 142 creates the regional tribunals, which have coordinate criminal jurisdiction with the High Court, all right, in all respects. And then it says that Parliament may by law establish such, courts and tribunals, that is, inferior courts and tribunals, as it deems fit. Okay? Now, to the question why we want to bring back the public tribunals. We want to go back and align with the internal logic of Article 125, Clause 1, that there must be participation by ordinary people in the administration of justice. If you recall, all the tribunals, district tribunals, circuit tribunals, regional tribunals, had a chairperson or chairman and two who was, mandatorily required to be a lawyer, and two, other persons who were non-lawyers selected from the community. So aside the traditional jury system that allows ordinary citizens to participate in the administration of justice in a limited fashion, the PNDC, in its wisdom, broadened public participation in the administration of justice through the tribunal system. Now, you referenced a report by Africa Watch. Of course, I am familiar with Africa Watch. If you go back to my CV, you realize that I was executive director of the Center for Public Interest Law, a human rights organization that I founded and ran for 10 good years, that conducted public interest litigation and represented persons whose human rights were being violated. So if you remember the famous case of Sodom and Gomorrah, I was a lawyer for the thousands of displaced persons in Sodom and Gomorrah using the Center for Public Interest Law. And so I'm very much aware of what Africa Watch stands for, right? But look carefully at the report, the date of the report. It will let you know that the empirical evidence for the statements that were being made, if at all, was gathered not from the era of the coming into force of the Constitution, but the era prior to the coming into force of the Constitution. Now, when it comes to our...
Chairman, with your leave, the document you referred to, was it Africa Watch?
Yes, Human Rights Watch.
Human Rights.
No, but he said Africa Watch.
No, let there be clarity.
What? Yeah.
No. Mr. Bafo, please, let's repeat again the full document you referred to, because we don't want a situation whereby Africa Watch will say that they have not made any publication. What is the name?
Mr. Chair, this is not Africa Watch, the newspaper. It is Africa Watch, a human rights watch group. When he's aware, it's not a newspaper.
Wait. The document is it an organization's report, or you are quoting from a publication?
It's an organization's report.
And what is the name of the organization?
The organization is Africa Watch, Human Rights Watch Group.
Okay, Leonard, then in reference to that, please quote it well. Respect.
Yeah, thank you, Mr. Chairman. I was very much aware of the fact that it's the human rights wing of the Africa Watch, but I was just referring to it in the manner that the honourable member stated. So if you look at the date, okay, my hunch is that the empirical evidence for a report dated very close to the first quarter of 1992 would have been from the pre-constitutional era, when the public tribunals were administering revolutionary justice in the context of PNDC Law 1. Now, if you look at PNDC Law 1, there was no human rights chapter. That was the Grundnorm. That was the constitution, the fundamental law of the land at the time. There was no human rights chapter. In resetting Ghana, we will reset it in accordance with the 1992 Constitution. And the 1992 Constitution is very clear, that the sovereign power of Ghana rests in the people of Ghana, in whose name and for whose welfare the powers of government should be exercised in accordance with this Constitution. Governmental powers includes the powers exercised by the judiciary of our land. That includes the public tribunals. I believe that it is not your view, honorable member, that the public tribunals would not or are not part of the judiciary. They are part of the chapter on the judiciary. And so they will be bound by Chapter 5, the human rights provisions, and the entire Constitution, guided by the directive principles of state policy in Chapter 6. And so the proposal in our manifesto is to re-establish the regional tribunals with criminal jurisdiction that is, coordinate jurisdiction with the High Court. And then we will have the circuit tribunals in all the districts, in all the, the regions, and then also the district tribunals that will also dispense justice in the various districts of our country. And I believe that if they are being regulated, and my proposal or my thinking going into this office is that we will enact a Public Tribunals Act that will be comprehensive, and that will, contain restrictions in terms of the conduct, of the affairs of the tribunals and the human rights violations that are, referenced in the Africa Watch human rights report will hopefully not occur. Not under my watch as the Attorney General of this Republic.
Thank you very much, Honorable Bafo. Before you proceed with your second question, Honorable Mahama Yariga has a follow-up.
Attorney General nominee, do you intend to establish tribunals that will use caning and lashing of people as one of their punishments? Do you intend?
Mr. Chairman, I do not, and that will not be permitted by the Constitution of the Republic. In fact, that will be inhuman and degrading treatment of our citizens.
Minority Leader also has a follow-up, so you may wait for your second question.
Honorable nominee, have you become aware of the establishment of the ORA?
Honorable Minority Leader, a follow-up question must relate to the preliminary questions or the substantive question asked. But this is completely unrelated to the substantive question asked. So hold it. When it comes to your turn, you can pose these questions. Honorable
Chairman, with respect, please hold your horses. Let me make a point. We are dealing with matters of public tribunal. We are talking about issues that go complementary, okay? As far as possible, from all that you've said. I am trying to appreciate the point you made in response to the question he asked, that would you set up a tribunal which would carry canes to be, chasing people here and there? You responded that no, because it will not be in accordance with law. Correct? In the same spirit, I am asking you that the ORA, that committee, which we've been told is to receive information from the public regarding supposed looting and all that. If you become aware of it, do you think that its establishment is in accordance with the Constitution?
relates substantially to Article 126(1)(b). This oral that we are bringing in is not related to the establishment of the tribunal as stated in the NDC manifesto. So I reiterate the point that you can hold it when it gets to your turn. You ask a substantive question, but this cannot be accepted as a follow-up question. Thank you very much, Honorable Leader. Honorable Bafo, proceed with your second question.
Honorable nominee.
Chairman.
So, Minority Leader,
Chairman.
I cannot ask a member to proceed with a question, and then you ask that he should hold on. This is unacceptable. It's completely unacceptable. So, Honorable Bafo, proceed to ask your second question.
Chairman, take it easy.
Would you want to forfeit asking your second question?
Chairman, take it easy. 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 The nominee, in response to a question as to whether there will be an establishment of a tribunal which will carry canes to lash people, responded that that would be unconstitutional. I am premising my follow-up question on the constitutional issue he has raised. You may disagree with me. Chairman, we are being cooperative, but please, he has raised a constitutional matter that if he establishes a tribunal with canes lashing people for the purpose of ensuring justice, it will be unconstitutional. Now, it is in that spirit that I am asking him, because he has raised a constitutional matter, that there are things that if you do, it will be outside of the constitution, and he as AG won't do it. So I am asking whether or not he's become aware of the aura, and if he has become aware of the aura, its mandate is within the ambit of the constitution because he has raised it. So it is flowing from the very answer he gave on the constitutionality of the functions of a publicly established body such as a tribunal. So, Chairman, I do not see why we should be locking horns on this matter. But however, if you insist, I will yield to you for us to make progress. If you insist, I will yield to you for us to make progress.
Honorable members, I insist that the question is unrelated to the question posed to the nominee relating to the establishment of the tribunal as contained in the manifesto of the National Democratic Congress. Honorable Bafo, may you proceed to ask your second question.
The question was, what is it that the high courts, regular high courts, are not doing that you need the tribunals to cure? That, Honorable Nominee, I didn't hear anything. But more importantly, on the question of the promise that you are not going to set up a tribunal that will cane people, Honorable Nominee, are you aware that there is the criminal practice and procedure of this country is regulated by statute, and that statute does not include private citizens called ORA gathering evidence which will be handed over to the Attorney General to prosecute? Are you aware that there's nothing like that in the criminal, in the statutes of this country? Are you aware? Yes or no?
Honorable members, I know the nominee is capable of answering the question. But in our Criminal and Other Offences Act, as well as the Procedure Act, committees are not stated. But Honorable Nominee, may you proceed to answer the question.
Well, I'm sure the Honorable Member himself well knows that Act 30, the Criminal and Other Offences Procedure Act, does not create bodies, organizations, agencies, or entities that are mandated to operationalize criminal procedure. It merely lays out the procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, there is nothing about oral in in Act 30. Now, the question whether oral is legal has been raised, by various people within the media, all right? Oral is the Operation Recover All Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then, let me hear from Honorable Layerga.
Mr. Chair.
He's coming in on a point of information.
Mr. Chairman, if you open the Constitution to Article 41, please everybody listen to this. Article 41 deals with duties of a citizen. 41F says one of the duties of every citizen of this country is to protect and preserve public property and expose and combat misuse and waste of public funds and property. So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Mr. Chair, my
Honourable members, to our guests, I will reiterate the fact that we do not clap in Parliament, but we rather say, yeah, yeah. Is that okay? Honorable Ayerga, you are even not supposed to react. So observe the proceedings in silence. Honorable Ayerga, we are grateful for the point of...
Notwithstanding Article 41F, the Criminal Offences and Procedure Act, Act 30, provided or has made provision for investigations, arrest, and prosecution of criminal offences. And it still doesn't include oral or private individuals acting. But my follow-up is this. My follow-up is this. My follow-up is this.
What you've just said was a preliminary comment, but not a follow-up question.
Mr. Chair, I plead with you to indulge me in the interest of Ghana.
You'll be indulged. Right. Ask your question. Go ahead.
Roxanne, you promised to protect.
Please go ahead with your last question.
Okay. So, in the year 2010, the NDC administration under Professor Mills commissioned the Constitution Review Commission that presented its report in the year 2012, for which a white paper was issued in June 2012. Hope you remember. The government accepts the recommendation that regional tribunal be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman of the regional tribunal, if any, should be absorbed into the judiciary as high court judges. This is by an NDC government. The question is that when you had previously accepted the commission's report to abolish the commission of inquiry, to abolish tribunals, and now you say you are bringing it back. Is it not double speaking? Especially when you have also failed to provide before us what the High Court is not doing that you want to correct with the tribunal. Is it not double speaking without any justification? Dated 2012, yes.
So what is the exact date on the report?
The report...
You are referring to the white paper?
I'm referring to the white paper.
The report of the Constitutional Review Commission?
I'm referring to the government white paper stating its position on the report.
Very well. Honorable nominee, your response.
Yeah, thank you, Mr. Chairman. I'm very much aware of the position stated by the honorable member. I was very intimately involved in the work of the Fiajo Constitutional Review Commission, which was headed by my own good friend and former colleague, whose secretary was my own good friend and former colleague, the current dean of the University of Ghana Law School, Professor Raymond Atuguba. I am also keenly aware of the fact that the government white paper accepted to abolish the recommendation of the commission to abolish the regional tribunals. However, an American justice of the Supreme Court, a justice of the Supreme Court of the US, very famous, Oliver Wendell Holmes, he once said that the life of the law has not been logic, but experience. When experience has taught us that there are deficiencies in our justice system. In fact, when the honorable nominee was talking about the honorable member, I'm sorry, I have been here since 9:30, you have to forgive me. When the honorable member was talking about delays, he's a legal practitioner and he knows that the traditional court system is also plagued with a lot of delays. You also know that sometimes they disregard the fundamental human rights of citizens. During the tenure of your own government, Afoko, Gregory, when a court of law ordered that he should be granted bail, you still callously detained him, and he's in detention now. That's a violation of the right of Gregory Afoko to liberty. So these things occur whether you are dealing with the traditional court system or a tribunal system. Okay? The good thing is to have men and women of integrity who will administer the law or administer justice in accordance with law. And that is what we are seeking to do with the re-establishment of the public tribunals. I think that our experience has taught us that the participation of ordinary citizens in the justice system is a good thing. And that is why, having thought about it, we are re-establishing it. But of course, we are governed, as I said, by a constitution, and I believe that there will be limitations to the powers of the tribunal as far as respect for the rights of persons appearing before them is concerned.
Thank you very much. I recognize Honorable Roxanne Nelson Kwame Eche Davamapo for a supplementary question.
Chairman, thank you very much. Professor Ayine, you are welcome.
Thank you, Mr. Chair.
You taught me, and you taught me well, and I'm very happy that you got this nomination. Now, you're also my chairman of the Subsidiary Legislation Committee, and I second chair you. And I know the quality that you put into your work. So you also taught me legal systems, union courts, or you are going to implement the law. because Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act.
You don't have the floor.
He says.
You do not have the floor. Even at point of order, I need to give you the floor. Honorable nominee, may you proceed to answer the question.
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC committee. So if you take the compendium, the green compendium, I think that was where it was done. And the idea was to take them out, in terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly, because the President has hit the road running, and we, his nominees and his appointees, are his, supplementary wheels. We have to help him, to run as fast as possible. So I will bring a bill that will comprehensively deal with the implementation of the letter and spirit of Article 142 of the Constitution. Thank you very much, Mr. Chairman.